Hello, my name is Attorney Walter Ruffnaut III, and I thought this would end up on the web by other attorneys or representatives or individuals, maybe even the government, putting up a reasoning as to why an individual would not be found disabled. Specifically, we're going to be focusing for 2019 because it is today, the 2nd of January of 2019. The question we're going to be answering is why you, the individual, the claimant, were not found disabled in 2019. We're going to split this up into some basic subcategories because this is a question most people don't even want to touch because it's so complex, but we're going to do it today. I've published more tutorial videos on how to do disability law than any other human being on earth. So at this point, let's begin. You either received a denial in a technical sense, meaning a technical denial, which is where you didn't submit something on time, you didn't meet the requirements of something in a timely fashion or an appropriate fashion. You are under investigation for something, you have criminal felony charges against you, things like that. Or you didn't meet one of the 5-step sequential process elements. So element 1 is SGA, meaning a money element. You can't earn more than $1,220 per month. Okay, so in 2019, if you earn more than that per month, and really they're looking for a couple of months, not just a failed work attempt, then in that case, what that equates to is a denial because you've earned too much substantial gainful activity, ergo denied. The next one is that your disabling condition didn't last 12 months or isn't likely to last 12 months because it's just not severe enough. You might have gotten into a car accident, but you've healed up since that point, and now you're in a situation where you're not in the disabled condition that you used to be. Element 3 is do you meet, equal, or exceed a listing or have medical equivalency to that listing, which is essentially where you have to meet the severity of a predefined disability or be similar in severity to one of those disabilities. A lot of people just think because they have COPD that they're severely disabled. A lot of people think that just because they have anxiety or depression that they are in fact disabled. A lot of people think that because they have an amputation that they are disabled. The reality is that while an ALJ may find you disabled, ultimately, even though you don't meet the necessary severity restrictions of a listing, those listings are very, very, very severe. For example, if you wanted to go ahead and get found disabled for an amputation, which is an easy one, I like to focus on amputation because it's a piece of the body that's missing. It's not some weird thyroid chemical imbalance. It's not some difficult to perceive when it became severe depression syndrome situation. It's literally one of those things where you either have the body part or you don't. So let's talk about it. In order to be found disabled for amputation purposes, you have to have both of your ankles and down gone. Both of your ankles and down gone. Or one of your legs and half of your hip gone. Or one of your legs and half of your hip gone. Now let that kind of sink in so that you understand the severity requirement here. Every year, including 2019 and 2020 and 2021, it becomes more and more difficult for an individual to be found disabled. And yet, people seem to, for some reason, think it is easier and easier to get onto disability benefits. Now, that may be part of the problem where a lot of people back in the day said, oh, I didn't have any problem getting on, or I did this or that. And then when they get kicked off the benefits, they try and do it themselves again, and they fail and have to hire an attorney. But in between there, where they told everybody that they were going to magically get them on the disability benefits train, they basically created, an ism or a feeling or a culture that it's possible and probable that you'll get onto disability benefits, when in reality, most people have a very difficult time getting onto this system. It is not a welfare system, but to some degree it has become that in modern society because a lot of individuals who can't find a job apply for it just to see if they actually can get onto the system. So we've talked about technical denial. We've talked about elements 1, 2, and 3 of the 5-step sequential process. Now let's hit element 4, which is, can you do the work that you did within the past 15 years? And the reality behind this situation is that a lot of individuals claim that they can't do the job that they did. And many of them are right. many of them did pretty technical or skilled jobs that they can no longer do. And that's good, and that's fine. However, let's talk about now element 5, the cleaver, as I like to call it, the one that defines whether or not you're really going to be found disabled. So let's talk about that. That's the element where they look to see whether there's any job in the national economy that you could potentially do. If not, work preclusive, there's no work for you. If there's no work for you, you're found disabled. But there's a lot of really simple, really simple, easy jobs out there. So let's talk about what that means. If there's a lot of really simple, easy jobs like tying shoelaces into shoes, maybe you've got a hand problem and you can't use your hands with detailed fingering-based work. Okay. Let's talk about a job where you're sweeping. Doesn't require fine manipulative features of your hands and fingers. Requires grasping, gross manipulative features, holding. Could you do mopping? Could you do shoveling? This is where they look at to see whether or not you could do a very simple and basic job in the national economy. Okay, a marker. You take a little marking gun, you mark the price tag on something. But aren't all the new marking guns a digital system where you enter in the information with the little tiny buttons on the top of it and then have to click it? Yeah, so it requires manipulative fine feature fingering, much more so than it used to. So you can either get a denial where they'll say that you can do one of these jobs. You could go back to element 3 and they'll say you're just not severe enough. Element 2, your disability hasn't lasted long enough. Element 1, you're earning too much per month. Or have a technical denial where you just didn't submit something in time. Then there's another type. Then there's the type where you get a decision from an adjudicator. That's your administrative law judges, your AAJs, Appeals Council, your federal middle district judges, your federal circuit court judges, your federal Supreme Court judges. You guys know the Supreme Court judges because of the whole Kavanaugh thing and what's going on there, and you understand, who they are. Every state has their own Supreme Court, but we're talking about the Supreme Court of the federal government right now, as in the people who are literally at the top of the chain. All right, so let's talk about that for a moment. Let's say that you get a decision from them as to your current situation. That could include a technical denial or one of the elements of the 5-step sequential process. However, there's usually some background reasoning to it. So they give you a definition or a layout or an element analysis as to why, in fact, you weren't found disabled. That will include, for example, considering doctors' evidence and their weight against other doctors' evidence. And then you get into certain situations where they look to see, okay, you had a regular physician and a nurse. The SSA sent you to, albeit once, a specialist. They might give that specialist a whole lot more weight than the person you've seen for 4 years. That is something you would appeal, because that is erroneous on behalf of the administrative law judge or appeals council or federal administrative judges at the higher, circuit district court levels. So there's reasons inside that where they'll talk about how you don't meet the elements of a particular listing, how you basically are not eligible for some technical reason. It still goes back to those two basic functional categories, the technical or the 5-step sequential, the elements. But the reality is there they actually break it up and tell you why. A classic one that people don't really understand is that you could get a technical denial because you're currently under investigation. I have some claimants, sometimes I'll get a call from the Department of Justice pertaining to them as to whether or not they are still or currently or have begun working. And what they'll find is that some family members hired them under the table and yada, 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 and so on and so forth. And they're claiming disability benefits, yet they're working and getting paid and all these things. In that particular situation, that would fall under a technical denial. But some people would give a different phrasing because, let's call it like it is, that's usually pretty involved. They investigate the person for fraud and conspiracy and yada, yada, yada. Never forget that the government is very quick to do an analysis for fraud or conspiracy. And yet the American people, when they claim fraud or conspiracy, have very little right to go ahead and claim this should happen or that should happen or the government should change this way or that way. That's why we have these elected officials, but as you've seen, the government doesn't really change that much because drastic changes are very expensive and they're unlikely to fix the problem in the first place unless they're, sweeping and massive and all these incredible words. So what I would say to you is this: you have to learn how to play the game when it comes to understanding the basics of how this system works. And I say play the game, a lot of people would be offended by that term. Screw them if they are, because that's the reality of it. But in law school, I used to call it learning how to play the game. It's elements. Everything is an elemental response. If you have a hard time understanding why you weren't found disabled, break it down into bullet points. Because when people think of bullet points, bullet points, bullet point, bullet point, bullet point. This happened at this date. This happened at this time. This happened with this person. Bullet points. Break it down into bullet points, because then you can have a better understanding as to where their logical connection came from. They're sitting there writing a report, validating their own decision. And in such, that validation is what's submitted to higher ups, who ultimately use it to either concur with their decision or disagree with it. Inherent in that situation, you basically have those 5-step sequential process elements, the reasons you could get a technical denial. And by and through that, you have to kind of figure out what are they going to say they use to actually deny you. I know that you don't know all the law. You especially don't know any of the federal case law, which is really important to do this stuff, but it's called like it is. You're not going to learn it anyways. What's important to do, if you think you might be able to do this on your own, is to get an opinion from somebody who actually does it. I've freely given out opinions for going on nearly 6 years now about what I believe their case would be strong on, and people have gone out and filed on their own. Here's the problem with that, though. Every year it gets harder, and we're no longer in the little bit harder didn't really matter that much. We're now into the little bit harder is affecting even the work that I do, using all the proper statutes, using all the proper federal agreements, the contracts, the expediting clauses. Everything's getting harder because the rules are changing drastically to be extremely pro-government. And in a very pro-government system, you have to look and see whether or not you have a right to these benefits. All right, so another reason that people get really upset pertaining to their denial is that they think that they have a right to disability benefits. And you do, so long as you follow and can complete successfully the 5-step sequential process and don't have any other factors that would cause a technical denial. This isn't like you can retire at this date, you've earned enough, you paid your way, now you get, SSDI benefits. And I get it. All of the people out there, your kids, they're not going to have pensions. I get it. They're not going to have systems where they donate money and get money back. I get it. Those are all dying away. The money system is all dying away. Companies are struggling to exist, to pay for health insurance. It's all dying away. And what that means is that a lot of people are going to be heavily reliant on disability benefits until they reach that retirement age. But here's why you need to stay on disability benefits when you get to retirement, and I mean full retirement, because you can ride SSDI all the way up until your full retirement age. And I know the age is getting pushed out to 67, and I know that in the future, in 2020 and 2021 and 2022, it's going to get pushed out to 68, 69. Pretty soon, people are going to be 70 before they can retire and start to get their full benefits. Which means a lot of those people are going to have disabling conditions, severe ones, because they're just too old. If you take a person that's worked in an office their entire life, right? And then you take a construction worker that's worked on a construction site his entire life. Who do you think is going to have a body that's going to fall apart by the time that they reach 65, let alone 66, let alone 67, etc.? Who do you think? The system is set up, unfortunately, because, as we've seen, the government can't handle any more fund taking from its super funds. But the system is set up to basically cater to those who can live the longest. A lot of people work their entire life, pay into the system their entire life, and then they die right when they get their benefits. Not uncommon, not unheard of. So the point of this whole video is to answer why you weren't found disabled in 2019. We've gone through technical denials, the 5-step sequential process. We've gone through some of the logic and understanding why a person might have been denied. But then there's this human element too. There's this expectation that you definitively should have gotten disability benefits because you paid in. And like we've said, you've got to be found severely disabled. It's not like retirement, even though SSDI and retirement benefits and survivor benefits and all those different types of benefits fall under Title II. SSI is different, that's Title 16. But the point is, with all of this, it's not like those other ones, where you have to meet just a few easy elements. It's, you reach this age, you're good to go, check it off, get done, move forward. It's just not like that. The way it works now is that you really need to prove that you were severely disabled during, the point in which you claimed your amended alleged onset date or your just general alleged onset date. Going forward, okay, until essentially, you are found disabled. Proving that you were severely disabled during that time, it's not as easy as it used to be. A lot of the doctors are now not willing to write down certain things. They're not willing to write letters. They're not willing to fill out RFCs because of the immense abuse that has occurred throughout the environment of medical doctors and specialists. So every year it gets a little bit harder to get on this program. And every year, many people get kicked off of the system because they just weren't disabled or they weren't severely disabled. The government kicks a lot of people off this system. It creates for them an overpayment situation usually because they opt to continue to receive benefits and can't prove that they're severely disabled. One thing that I would say to you is, if you want to keep your disability benefits, keep going to different doctors and keep going and having them doing their different tests to get multiple opinions, because that gives you more weight to your evidence. It gives you more people on your side of the fence who are positive for you. If you don't want to keep your benefits, if you currently have them, then just don't go to the doctor. You'll lose them because they'll put you through a CDR and they'll likely find that you're not disabled if you truly aren't severely disabled. And if you want to obtain your benefits, then my best advice to you is retain an attorney, retain a local attorney, or just retain an attorney that you trust. Do not go with a big box firm. They are the absolute worst scenario situations that you could get yourself into. There's no immediate fix to the problems that they create, and then I have to go and correct a lot of them. The big box firms, what do I mean by that? The ones that are out there advertising on TV over and over and over. If they had enough clients, they wouldn't need to do that. The best firms, they make it by literally word of mouth. That's how we made it. We don't advertise on TV. We've never advertised on TV. We don't advertise on the radio. We've never had to advertise on the radio. It's because we're basically your neighbor's attorney. And so that's the type of firm you want to pick. It's the one that works the hardest, great success rate, and essentially is one capable of handling weird situations. A lot of law firms, if you don't fit into you filled out this paperwork, you filled out that paperwork, we sent it in. If you don't fit into that system and something weird pops up, they'll drop your claim because they don't want to have to deal with it, because to them, you're just a number, and let's call it like it is, you're not worth the extra time to have an attorney sit there and figure it out. That's why at those big firms, you see a lot of people leaving them and getting angry and joining a smaller firm, which is how my firm got, heavily started. A large percentage of claimants came to us from all of those big box firms. It helped kick us off and get us rolling. I hope I've answered why you likely have been found not disabled in 2019, so that you have a little bit of a better understanding. And I hope that you start to think of this as more of a bullet point system, as opposed to this emotional, I should have been found disabled because I'm this person, and this is my name, and Spartacus, da 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 da. That's a bunch of emotional crap, and that's not what we use to actually adjudicate these claims. So just keep that in mind, because I want you to be found disabled. I want a lot of people to be found disabled. I represent and talk to thousands and thousands and thousands of people a year, and the bottom line is that the moment you throw up that emotional angst, that emotional charisma, if you want to call it that, and you get down to the bottom line of what you need to be found disabled, then at that very point, you are where you need to be to start the process. And if you're sitting there thinking, I'm not at that point, or of course I'm at that point, or yada yada yada, be honest with yourself, because if you lie to yourself, It's like, taking an exam and not actually knowing the information. And then you're sitting there trying to do something and you can't figure it out because you didn't have the knowledge. You're just cheating yourself. Don't cheat yourself. Be honest with yourself. Acknowledge what you've done that's right. Acknowledge what you've done that's wrong. And then take the next step to kick yourself in the butt to get going in the right direction. All right? My name is Attorney Walter Roofnaut III. I'm with Disability Resolution PA. If you'd like a free consultation, that's fine. Shoot me an email or call me. Email is usually better for free consultations because I can shoot you a quick update back. If I want to give you a call, make sure you put your phone number in there so I can. Keep in mind I work with thousands of people. I have a huge client load, so it's not one of those things where I have unlimited time. I try to help as many people in the community. I try to give as many talks as I can in the community to explain how this stuff works. When in doubt, ask somebody who knows about it. Even if it's not me, reach out to somebody. If you would like a custom video made, that's fine. Shoot me an email. If you would like something in particular addressed, that's fine. Shoot me an email. And then finally, of course, this video may not be up to date, so give me a call, shoot me an email, and I'll catch up with you to give you the most up-to-date information. All of this is pretty much going to stay up to date other than the SGA amount, which is that $1,220. All right. Give me a call if you need to, 407-279-1754. Again, 407-279-1754. And the email is info@disabilityresolution.com. Again, info@disabilityresolution.com. Thank you. Bye-bye.